So let's do a little Stanford Revisited. Since we spoke, there's been a little bit of a new event. So, uh, Dean Jenny Martinez is not only the dean of the law school, she is also a constitutional law professor at the law school, and she is teaching con law this semester. When she showed up to class this week, her blackboard, which isn't black anymore, what do you call it when it's a whiteboard? Her whiteboard, I guess that's what it's called. Her whiteboard was fully papered over with signs that read counter speech is free speech and other similar slogany things. And on her walk from her office to her classroom or her classroom to her office, I forget which direction it went, students created a human corridor. About 1/3 of the Stanford Law School class was present. They were all wearing black, and it was meant to be a walk of shame, protesting her statement in which she said that the law students at the Duncan event had violated the school's policy and that the dean, the DEI dean, had acted counter to that policy as well. So both pieces of that they disagree with. Now, I think it is worth pointing out that if they had done that to Judge Duncan, we wouldn't be talking about it. What they did is just fine.
Yeah.
Posters in class and a silent, corridor protest? No problem. That is counter
Right.
speech.
Right. Exactly.
Counter speech also could be holding an event at the same time in a different room. Counter speech could be holding an event right afterwards, or out in the quad. I mean, counter speech is not speaking at the same time, and it is not subject to majority rule, and it is not subject to who can be the loudest. That's not counter speech, y'all.
Right. I mean, and that's why, remember at the very beginning when we were talking to Judge Duncan, I specifically asked, was this a situation where you had occasional bursts of heckling or groans of disapproval or shouts in response to something you said, which is annoying, but you can give your speech, and audience reaction during a speech is not the heckler's veto? Or was this a situation where you faced a kind of a wall of sound where you couldn't be heard? And he clearly said it was the latter. There are people who have come forward and said, no, 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 that's not the case. It was not the case that he couldn't deliver his speech. And so far as I know, there is no publicly available recording of the entire event. Now, allegedly, Stanford may have made a recording of the entire event, but I don't think that there's any publicly available recording of the entire event. What I've seen certainly qualifies as much more in the heckler's veto world. And look, if the Stanford law students are operating under the assumption that there was not a shout down and they're being punished, okay, I can see your point. But if you're operating under the presumption that the assumption that you have an ability to shout down a speaker, you need to stay in law school a little bit more. I mean, come on.
This is the problem. The arguments from the other side are being a bit muddled.
Yeah.
And I don't know whether they're being muddled because the defenders don't quite have the facts, so they're muddled, or that the law students don't quite know the law, so they're muddled. But the defense falls into a few different buckets, and I think we should discuss each one. Defense number one, which is what you just said, is he wasn't actually shouted down. There was random intermittent heckling, which is not actually heckler's veto, and that is First Amendment, protected speech. And let's just, for the purposes of this conversation, say that Leonard's law, which applies parts of the First Amendment to private universities in California, let's just treat this like we're talking about the First Amendment for our purposes. Okay, so bucket number one, they didn't actually heckle him. There was intermittent yelling in response to some of his more egregious statements. So there was no disruption to the event. Okay, like you just said, David, if that's your argument, then actually, David and I are right here with you.
Right.
There seem to be a lot of facts that's a factual question.
Right, exactly.
So present those facts, make that, factual case. No problem, because Judge Duncan and the reporters who have talked to students who were in the room say that it was pervasive. Okay, that's bucket number one. Bucket number two, counter speech is free speech, which is what we just talked about. That's just like heckler's veto. There's nothing wrong with it. Majoritarian rule, the loudest voices in the room, that's how this works. That's literally not how this works.
It is not how this works at all.
Counter speech is something different than heckler's veto. Third bucket, which I think is also interesting, is yes, the event was disrupted. Yes, we heckled him off the stage, so that he wasn't able to speak. That's called civil disobedience. I am also very sympathetic to that argument. If you believe that there is a law or a policy that is unjust, and you would like to highlight that, you can violate that policy or law to prove your point. And in this case, the student's saying that the free speech policy at Stanford allows odious speakers to come to their campus who are rude and dismissive and believe things that are outside the acceptable norm of conversation. And so, yeah, we violated the rules and Leonard's law potentially. That's what we felt justice demanded. I got no problem with that argument. But civil disobedience also means that you accept the consequences of violating the rule. And right now, the students seem to be saying, the civil disobedient bucket of students seem to be saying, we violated the rule under civil disobedience because it was unjust, and that's why we can't be punished. What? I don't follow that.
Yeah. No, you're right. And this is actually endemic. I have seen this argument in the context of interrupting speakers. I've seen this argument in the context of blocking interstates, for example. I've seen this argument all the time in the context of disruptive protest. It's just civil disobedience. Fine. Understood. Peaceful civil disobedience there's an honorable tradition of peaceful civil disobedience in this country. Accept the consequences. That's part of it, is accepting the consequences. And so, yeah, absolutely make that argument. But if you're making that argument, again, you're with us, because you would say, yeah, there are penalties, there are consequences for this action. And the idea that you can violate the law and not accept the consequences is not civil disobedience. That's much more heckler's veto.
As someone said, it wasn't called Letter from a Birmingham Coffee House.
True. Well said.
Okay, next bucket is Judge Duncan started it. That when he took the podium initially, and again, this is somewhat factual, but also not in my view, that when he took the podium initially, he started out by saying things like, I'm not blind. I can see this outpouring of contempt. At this school, the inmates have gotten control of the asylum. Y'all are juvenile idiots. Before he even got into the room, walking down the hallway while they were protesting him, fully in compliance with Stanford's speech policies and Leonard's law, that he started recording them with his iPhone, and that he was getting up in their faces by doing so. And that's when one student turned to another and said, like, this is about to get real. Like, it's on now. So Judge Duncan started it. Here's my take on that bucket. Once a speaker has been invited to campus and the school has put their imprimatur on it, that speaker can stand up at the podium and say outrageous things to you. Imagine if they were a shock jock or an insult comic or something. It doesn't change the First Amendment analysis whatsoever.
Not at all.
So look, I'm not sure that the facts totally back up that Judge Duncan, when he first stood at the lectern, said mean things to them. My impression from, again, the reporting and from Judge Duncan is that he started talking, they started heckling, and then he started saying mean things to them, which also just kind of makes more sense. But let's say the alternative, right? They're holding up mean signs. And so he says something to them right off the bat. I'll accept those facts for the purposes of this bucket. Doesn't make one bit of difference to the legal analysis.
Yeah, exactly. And on the videotaping point, and by the way, I love that we still use the term videotaping, although because nothing is being
It's neither video nor tape.
It's not being taped at all. Anyway, so on the video point, this actually echoes back to something we talked about before, which was when we talked about the confidentiality of law school protest or the confidentiality of law school dissent. And I do think that some of these protesters actually view any sort of publicity of their protest as an affront. And so when he starts taping them,
Which is directly contradictory to the civil disobedience point. The point of civil disobedience is to bring attention to unjust laws. So you need attention to do that.
exactly. And also, they just put up a bunch of posters of Federalist Society, the pictures of Federalist Society members of the board. So the idea that, we've got these extremely delicate folks who can't have their picture taken by somebody they're protesting, or the view that taping a protest is somehow inherently provocative, is a little weird to me. Everyone knows the ethos of this time, which is when you start taping is not necessarily aggressive, it's often self protective. In other words, the instant you start taping is the instant that everything is being recorded. And if you feel like you're about to be treated unfairly, beginning to tape somebody or record somebody, to use more precise terms, is a rational thing. I mean, this is something that happens when you're afraid that you might suffer some sort of abuse at the hands of police, for example. Begin using, recording the encounter on your telephone. A lot of people do this as a purely defensive response to a perceived aggressive or dangerous situation as a way of protection and accountability, not as provocation. To view that as inherently provocative, I think goes back to this entitlement we've talked about before in the context of Yale is what I get to do in law school is what I get to do in law school.
It's not Las Vegas, y'all.
Right, exactly. Exactly. What happens at Stanford does not stay at Stanford.
Now, that being said, I want to acknowledge some of the fallout of that, which is simply true, which is it is going to have a chilling effect. It's going to have chilling effect both on the people willing to protest, and it's going to have a chilling effect on the people willing to sit in a room to hear a speaker that they know will be protested, because people on the protest side were videotaping, people on the FedSoc side were videotaping, Judge Duncan at one point's videotaping. And so, yeah, if you don't want to be part of that whole mess, you're not even going to be able to show up to hear the speaker. I I think that's part of how to understand Yale's response to what happened at Yale included a no surreptitious recording rule. Now, that would be different than I think sort of open notorious recording with an iPhone where it's very clear. But nevertheless, I think that is why Yale instituted that. There's some problems with that, as we've talked about. In the case where there was actually a surreptitious recording, it was a member of the administration threatening a law student. So that's not really what we're talking about. But fair enough, surreptitious recordings have an effect on a culture as well. That's not great. I acknowledge that. Okay, David. Now I want to kind of flip the script here, because there's also, well, on both the left and the right, talking about this Q&A, that the students' questions were outrageous, and that somehow maybe violated the rules or the policies or whatever, and that the judge's response was outrageous, and that's why the questions were what they were, and that he deserved everything he got, yada, yada, yada. Here's my response to that bucket. Yep, Q&A is what it is, man. I think that we were making a distinction between can versus should. The students are allowed to ask whatever questions they want and not violate Stanford's policy on free speech. There might be some other civility policy or something, but as far as I'm concerned, I only care about the free speech aspect of this. They can ask whatever they want. Should they ask questions about a judge's wife's genitalia? I would suggest that they should not, but that's a should question. And in the reverse, should the judge have called them idiots and belittled them and denigrated them? No, it wouldn't have been my choice. But it has nothing to do with the legal analysis whatsoever. So the Q&A in that sense is irrelevant.
Right. No, you nailed it. I mean, you nailed it. Should they ask those questions? Of course not. Of course not. Should the judge have snapped in response? I mean, we asked him very specifically about that. Like, how does he feel about that in hindsight? And so, we asked him about that question. And look, if I was mapping that out and my preferred response in that circumstance, I wouldn't do it. And as we talked about, when I've had a chance to prepare for an attack, it's very different. My response has been very different than when it's sort of a surprise. um, and that's kind of part of being a human being. But I think that the should and the must distinction there in the Q&A is an important one to draw. Absolutely.
If there had just been miserable, aggressive Q&A with Judge Duncan at Stanford Law School last week, we wouldn't talk about it and nobody would care. Maybe it would get, some attention on Twitter about the specific question that we've been talking about, but then we'd all roll our eyes and be like, well, kids are going to kid. I heard from one source that that person might have been an LLM. And for anyone who's been to law school, we can all roll our eyes at the LLMs, okay? I get it. Little LLM shade on this podcast today.